If that's a decision that they truly would not like to continue to live in whatever condition they may be in, it involves withdrawing medication many times. It involves withdrawing food and water, and that's not a pleasant process. Other steps are taken. An assistive technology assessment can also be done. Maybe there's assistive technology out there that would allow you to communicate if you're not able to communicate on your own, if you're not able to express your own wishes using your natural voice. There's all sorts of stuff out there that may allow you to communicate. Would that make a difference in your decision as to whether or not you wanted these steps to be taken? Cognitive assessments, same sort of thing. You can require that before any additional steps be taken that you be given cognitive assessments by several professionals so that you have mandated more than one opinion. You can also, for instance, say, well, if I am in a position where I can't express my wishes, I want someone out there looking for cutting-edge therapies and cutting-edge treatments. And I want that kind of research to be done before any other steps are taken. You can mandate that. So those are just some examples of things to incorporate into living wills, advance directives, for both yourselves and for your loved ones with disabilities. And by doing that, again, you're able to have as much control as possible over the process and make sure that your rights are respected as much as possible during the process. And I think that's the name of the game for everybody. Now let's turn to discussing guardianships and alternatives to guardianships. Now in Florida, we have a couple of different types of guardianships. Oftentimes, when people refer to guardianships, they're really talking about plenary guardianships, or what I call full-blown guardianships, where a petition is filed in court that says John Smith needs someone to be able to act on his behalf and needs a guardian in legal capacity so that he's okay and his property is okay. In those types of cases, the judge appoints an examining committee who will go out and they will typically interview the person who is named in the court documents that is said to need a guardian. They'll talk to them, look at medical records, maybe talk to family members or friends, and then they will report back to the court. And if they report back to the court saying, yes, this person needs a guardian, the court typically holds a hearing at which the judge determines the extent of the guardianship to be established and removes various rights from the person in question. Now, in Florida statute, there's a whole list of rights that can be removed from a person. Some of them can be delegated to a guardian, some of them can't. Like the right to determine where you live. That's a right that can be removed from you and delegated to a guardian. The right to vote, that can be removed from you, but you can't delegate that to a guardian. That would be, in essence, giving the guardian 2 votes. That can't be delegated. The right to marry, that can be removed from you, but it can't be delegated to a guardian. The guardian can't make those types of intimate decisions for you, regardless of whether you're determined by the court to be legally incapacitated and need a guardian. Those things are so basic to ourselves and our own rights and makeup that the legislature's determined, no, we are not going to go there. We are not going to allow a guardian to make that decision for somebody. So the final order will set forth all of those things that have been removed, those things that are delegated to the guardian, and then they will issue orders that legally empower the guardian to act on behalf of the person with disabilities. Now that's a full-blown guardianship, and typically there are proceedings to appoint a guardian of the person and a guardian of the property. Usually with persons with disabilities, those come together, but they can be separated. Guarding with the person, they're self-explanatory. Guarding the person is, okay, this person needs someone to be able to make decisions for them in their best interests. Can't touch the property if that's all they are. Guardian of the property, same thing. They may not be making decisions about where the person with disabilities lives, for instance, but they can make decisions about what happens to whatever property they have. Now, if there's not a lot of property, or if there's no property, then obviously you don't need a guardian of the property. But again, with lots of persons with disabilities, both of those are combined. And usually a single person or mother and father are appointed as guardians of the person and the property. Now, that's under the full-blown guardianship statute. The full-blown guardianship proceedings, they can be not necessarily expensive, but oftentimes it's not cheap. You have to have an attorney. If you're going to move for a guardianship for a loved one, you're going to need to hire an attorney. There's expense involved in that. There's court costs involved in that. It can easily run up to a couple $1,000s even for uncontested cases. Now, a less expensive and a less intrusive version of guardianship is something called the guardian advocate. Now, the guardian advocate came out of the developmental disabilities community, and it's really designed for the developmental disabilities community. Under the guardian advocate statute, a person can be appointed as a guardian advocate for a person with developmental disabilities, and they can be legally empowered to take actions on behalf of the person with disabilities. But the beautiful thing about the guardian advocate statute is that it's much less invasive, much less intrusive, much less complicated than full-blown guardianship proceeding. Under the guardian advocate proceeding, there's not an examining committee. The proceedings can move much quicker through the court system, within 30 days many times, as opposed to often 60 to 90 days with a full-blown guardianship. Oftentimes, the reporting requirements are much less under guardian advocate than under a full-blown guardianship, so that that paperwork burden is reduced on the guardian advocate. And the beautiful thing that the legislature did this past session was they removed the need in many cases to have an attorney to represent you in guardian advocate proceedings. So that has dramatically reduced the cost in a lot of these types of cases. Now, from a practical standpoint and from a human standpoint, also in a guardian advocate proceeding, there does not have to be a formal finding by the court that a person is legally incapacitated. There does not have to be a finding by the court that they have to have their rights removed. Now, that obviously, for self-advocacy and for a number of reasons, that can be very important and that can be very worthwhile. The court can simply say, yes, this person with developmental disabilities needs someone to assist them. That person who's going to assist them needs legal authority in certain circumstances, like dealing with banks, like dealing with healthcare providers. We can do that. We can give them that authority. We're not going to find that the person with disabilities is legally incapacitated. We're not going to remove any rights, but we're going to give the court stamp of approval. We're going to give the guardian advocate the legal authority to be able to do those types of things for that person. Now, let me also say that oftentimes in these cases, it is when you're moving for some type of guardianship, it's not a fun proceeding, and I'm not going to try to sugarcoat it. It can be difficult for all persons involved, particularly not just for the person with disabilities, who obviously is subject to having some of their rights removed, But for family members, as parents of children with disabilities, and I have 2 children with disabilities myself,